Good afternoon, Your Honors.
Good afternoon.
My name is Matt Uten, and I would like to reserve 5 minutes for rebuttal.
That'll be fine, 5 minutes.
Your Honors, the facts in this case is Ms. Jordan is a paralyzed individual from an accident she had earlier in her life, which means she has to rely on services such as ETHRA to provide her transportation to and from doctor's appointments and wherever she goes. She is wheelchair bound, and on July 13th in 2023, she was receiving one of those rides from ETHRA. Her wheelchair entered the wheelchair lift, and the ETHRA employee did not let it all the way down, and Ms. Jordan fell off of the wheelchair lift, out of her wheelchair, and onto the ground. The ETHRA employee asked her at that time, "Are you injured? Are you okay?" And I'm paraphrasing this. To which Ms. Jordan replied, "I don't know. I'm paralyzed. I won't know until I see a doctor."
Counsel, why isn't she at least on inquiry notice from that date? I mean, she knows she fell, she knows she hit her face here, right? Mm-hmm. Doesn't know foot injured how much, if at all, let's say. But why isn't she at least on inquiry notice with the clock starting from that moment?
Your Honor, that's a good question. I would point to my case that I have cited, Wyatt v. Best, that was decided by the Tennessee Supreme Court, which discusses the asbestos case. And I would make the analogy that she was put on notice that she had a duty to inquire about this. Just as in Wyatt, when they sent the letter out, I'm not sure if Your Honors are familiar with the case, you probably are, but in that case, in May of 1989, the employees at the plant were sent for an asbestos screening in May of '89. In November of '89, they received a letter from their company saying, it shows the possibility of an asbestos-related disease and that they should seek further testing. Mr. Wyatt sought treatment on March 26th of 1990. In May of 1990, he filed his complaint. Well, he goes back after that and tries to amend his complaint, and the defense says, no, you can't do that. You're time barred via the statute of limitations. And the court in that case says, no. You were put on notice that there was an injury by that letter, even though that letter says it shows the possibility of an asbestos-related disease. And that letter also said, go hire a lawyer to protect your rights. So I make the analogy between that case and this case due to the latency of the injury, both in the asbestos case and in Ms. Jordan's paraplegia. She doesn't know she's injured, but I agree with you, Your Honor. That does put her on notice that she is to do her due diligence and go find out if she is in fact injured.
Why doesn't the clock start that day then? I mean, if I'm on inquiry notice, and I know, and she falls under those circumstances, and that we seem like we're pretty far down the road in terms of negligence, and that she's fallen, she knows she hit her face at a minimum, and why isn't the clock starting from then? I mean, she knows she needs to go get her foot checked out or her leg checked out.
Legally cognizable injury, okay? Breach of the duty by the plaintiff causes legally cognizable damage. In this case, yes, she knows she fell, but that's not the standard. The standard is, do you know you have damage? What are your damages? This, what you're arguing for, Your Honor, that would require Ms. Jordan to file a preemptive complaint. She doesn't know that she's injured yet. She doesn't even know what her injuries are.
I'm sorry, you said she doesn't even know that she's injured yet, correct?
Correct, Your Honor.
Not just the degree of injury.
Correct.
She doesn't know she was an injury.
She has no feeling in her legs, Your Honor.
I understand, so
right.
She doesn't know there's an injury.
She does not know. And the discovery rule applies and this is from the defendant's brief that cites Smith, The discovery rule is appropriate only when a plaintiff's injuries are unknown or unknowable. That's why we would request, and that's why we argue that the trial court, in error, stated that she had the injury on July 13th. And she may have, but she didn't know it, and she couldn't have known it due to her medical condition and her lack of feeling in her legs until she saw a doctor, just like in Wyatt. They knew something was wrong when they got the letter, but they didn't know what it was or the extent of it. They didn't have the legally cognizable injury that it requires. So to flesh that out further, that would have required her to file a complaint and state what? I may have an injury, I just don't know yet. And it's not an issue of what she found out later. Your Honors, this is an issue of when does the statute commence, okay? It is not when did she, or why didn't she do it sooner? She could have, of course she could have. But the rule states it doesn't start until you have a legally cognizable injury. And Ms. Jordan didn't have that at that time. And the trial court, on page 5 of their order, states that plaintiff had a duty to exercise due diligence to inquire about the date of the incident which caused her alleged injuries. Her failure to do so should not be excused. As a result, the discovery rule should not be applied. That's not the standard for when the discovery rule applies. The standard for when the discovery rule applies is if you have an injury that's unknowable or unknown at that time. Then the discovery rule applies. And we argue that it does in fact apply in Ms. Jordan's case.
Counsel, who bears the burden for coming forward with facts to put, I guess, with regard to the discovery rule? And is the burden on opposing counsel to negate? Is the burden on your client to demonstrate lack of knowledge, that she wasn't aware she was injured? And who has the burden with regard to that factual showing in this case?
I would argue, Your Honor, that based on the motion for summary judgment, they have to have the burden of proof to show that there's no indisputable fact to, let me look this. There's no reasonable trial. I'm sorry.
Isn't there responsibility? Thinking about Red Wing here, and in terms of thinking through this, initially burdens on the defendant come forward, statute of limitations as a defense. But if you're going to say, well, okay, it looks like it's been a year since the injury, but discovery rule should apply here, why isn't the burden on your client to present the facts that would show the discovery rule was applicable in the circumstances of this case?
Your Honor, I believe that Ms. Jordan did provide that information. I believe that we knew from the video, or we later knew from the video, that the incident happened on July 13th. Okay, they put that in their in their factual response. We didn't dispute that. We know that it happened on July 13th. But the issue is, when did she find out about it? And
what were the facts that were put forward before the trial court judge with regard to her knowledge of, I understand sort of from a pleading perspective and thinking through this, she's has a disability that prevents her from being able to feel. Is that fact actually before the trial court in the, with regard to the summary judgment in this case?
There are facts. When I got into the courtroom that day, I discussed this issue with the trial court judge about my client not being present and not being able to testify, and that I had medical records that would suffice to have that fact into the record at that time. And the trial court judge told me that we don't have witnesses at motions for summary of judgment, and we don't have evidentiary hearings. So I did not introduce that medical record, that single medical record that shows on the 18th that she had the fractured foot. So I didn't do that based on what I was told by the trial court at that time. And that's on page 4 of the transcript.
Had the defendant answered the complaint?
Yes.
What did they say in response to your allegation that, did the complaint have an allegation that she was a paraplegic?
Yes.
Did they admit that in their answer to the complaint?
I don't recall that exactly, Your Honor. I would have to look at it. But I believe they admitted that she's a
I'll ask them.
paraplegic. Yeah.
I'll ask them.
And that's my time.
You have your time for rebuttal. We'll hear from the appellee. Pull the microphone down, please.
Is this okay? Okay.
A little bit more.
Oh.
We want to be sure we can hear. Okay, thank you.
May it please the court, my name is Yasmin Lee Parker. I am with the Knoxville Bar and I represent the Appellee East Tennessee Human Resources Agency, or ETHRA. This case is brought on appeal from the trial court's granting of ETHRA's motion for summary judgment. This cause of action arises out of an incident that occurred on July 13th, 2023. The plaintiff, or the appellant, Ms. Lindsey Jordan, filed her complaint pleading a general negligence claim against ETHRA, claiming that the incident occurred on July 16th, 2023, claiming that the incident occurred on July 22nd, 2023, and then filing this complaint on July 16th, 2024, 3 days after the statute of limitations had already expired. At the time of the incident, the plaintiff knew or had inquiry notice that an injury had arisen from the incident. The plaintiff now claims that the discovery rule applies to this case.
I mean, what shows that the plaintiff knew that she had an injury?
So when the incident happened, Ms. Jordan had utilized ETHRA's vehicle van to transport her to a resident from, I believe it was a medical appointment. And as she was exiting the vehicle, her and her wheelchair fell off of the van. In her complaint, she states that, in the complaint, she states that she fell out of her wheelchair directly onto her face, that her left foot got tangled in her wheelchair, and that her wheelchair fell on top of her. She was present for the incident. She was there for it. She was aware and competent, and nothing in the record would indicate otherwise.
Excuse me. My question is not whether or not she knew the incident happened.
Right.
Obviously she did. What is there showing she knew she had an injury? Not the extent of it, but what's there showing that she knew that she had an injury?
Well, at the time of the incident, she was present for it, and she claims that her legs were tangled up. I mean, I think whether, for the statute of limitations to begin at this time, it's whether she knew an injury occurred or that she was put on inquiry notice that the possibility of an injury had resulted. And I think at that time, I would argue that she had inquiry notice that an injury had occurred, that she was put on alert of sufficient facts that an injury had occurred.
Okay, how? I mean, help me here. I understand that she knew the incident occurred. She knew that her foot was tangled in the wheelchair. Mm-hmm. How did she know, or when did she know that she reasonably should have known, not the extent of any injury, but that she had an injury of any kind?
When she fell, she had told the ETHRA driver, and this is in the incident report that the ETHRA driver had filed with ETHRA, that the ETHRA driver had broken her legs. going on in the complaint, the plaintiff also states that at an unrelated medical appointment, the plaintiff informed staff of her recent fall and requested that they examine the foot that got caught underneath her during the fall, acknowledging that she knew that an injury was likely or that there was a possibility of an injury. Now, this was upon her own request and showing that although she was paralyzed, she knew that an injury was possible prior to receiving any medical opinion from the doctors that she was present for on that July 18th date. So I think that would indicate that she knew that there was a possibility of something or that an injury did occur.
Okay, go ahead.
So again, the plaintiff claims that the discovery rule applies to this case to delay the accrual date from July 13th to July 18th when she went to the doctor and I guess told the medical physician that she was injured. However, the discovery rule does not apply here. The discovery rule is an exception to the statute of limitations that applies to cases where the plaintiff does not discover and reasonably could not be expected to discover or have the right of action.
Who has the burden then with regard to the facts as to the discovery rule? So where is the burden on your side? Is it with opposing counsel? Who has the burden with regard to the discovery rule, the fact showing the applicability or not of the discovery rule?
So I guess in terms of the discovery rule coming from the defendant's standpoint, we have the burden to plead affirmative defenses, and our affirmative defense was that the statute of limitations had expired. And so I think at that point, plaintiff is required to rebut that, but even with the motion for summary judgment, we brought the claim that that the statute of limitations had expired, and so I think at that point the plaintiff was required to show that the statute of limitations did not expire or that an exception such as the discovery rule applied to this case. And the thing with that is the discovery rule was not mentioned in the complaint. The first time it was brought and argued was in response to ETHRA's motion for summary judgment.
I'm going to steal the chief's earlier question. Do you know if the answer admits whether Ms. Jordan is paraplegic?
I'm not sure. I can look right here. I have the record in front of me.
Are there any facts outside of that were put before the trial judge in the back and forth with regard to summary judgment that state that she is a paraplegic?
Other than what the plaintiff has claimed, I mean, there were no medical records submitted. I don't believe that any facts were brought before the court.
Is there any proposed statement of undisputed material facts that lays out?
We did submit a statement of undisputed material facts.
Does it address whether she's paraplegic or not? Is there any responsive filings that indicate? I'm trying to figure out if the trial judge has, whether it's in the form of an answer, whether it's in the form of responsive. Did the trial judge actually have, and there's awareness in terms of the complaint, but was that fact actually before the trial court judge?
We filed a statement of undisputed material facts, and we stated that the plaintiff was wheelchair bound and used ETHRA's services, and that was admitted. I do not see in my statement that I addressed that she was paralyzed because there was no way for, I don't see that in the statement of undisputed facts. So I am not sure, Your Honor.
You're not sure what the answer, whether it was
if we admitted it or not, I'm not sure.
Right. I don't want to hold us up longer.
Okay,
on
no,
that
that's
point,
fine.
so
Okay, yes. I would like to address real quick the case that Mr. Uten had cited to, Wyatt versus A Best Co., and where he compares this case to the asbestos case. I think first, there's a difference in the injuries, whereas asbestos is a creeping illness that is, I think one is diagnosed with over time, over long-term occupational exposure. And so I think that's different from the paralysis injury that Ms. Jordan has. The court held that the statute of limitations accrued in the year of the 1990 when all of the plaintiffs were medically diagnosed for asbestosis, rather than the letter that was sent out to them in I believe 89. And the reason for that is because the big difference in the injury of asbestosis. One cannot point to a specific date or incident in which someone has receives asbestosis. It's something that occurs over time. And so I think the court mentioned that because it requires medical certainty to diagnose, and that is the date that the statute begins, because there's no other date before that can be pinpointed and identified to when asbestosis was contracted. Whereas here, the date of the incident is when the statute of limitations should begin, because that is the date in which the incident occurred, in which she can pinpoint her injury to exactly when it happened. With asbestos, even though that letter had, put them on notice that they may have been diagnosed with asbestos, that may have been is the uncertainty that the court talks about, and why the 1990 date, when they had medical certainty, was the date of the statute of limitations. So I would argue that the two cases are different, and that it wouldn't apply in this case. Ms. Jordan had the incident occurred on July 13th, and whether or not she knew the extent of it, or if she knew that she was injured, I think she was put on inquiry notice of enough of facts to let her know that an injury may have occurred on that date. I think we go to Young v. Enderpack, and the court talks about how the discovery rule is not designed to tack on days or weeks to the statute of limitations. And so with a case like this, I believe that because Miss Jordan was finally able to go to the doctor on July 18th does not mean that the statute of limitations accrues on that date. It accrued on the date of the incident.
Let me interrupt you again. Tell me if you agree that this is or isn't the current state of the law, the statement out of the Supreme Court opinion from some time back, whether the plaintiff exercised reasonable care and diligence in discovering the injury or wrong is usually a fact question for the jury to determine. Is that the current status of the law? I mean, that's still the law. I'll make sure the Supreme Court hadn't changed anything.
Are you, sorry, can you repeat that one more time? You said whether...
This is a quote out of the Supreme Court opinion that opposing counsel referenced, I think, Wyatt versus A Best, one you've been talking about.
Okay.
It says, whether the plaintiff exercised reasonable care or diligence in discovering the injury or wrong is usually a fact question for the jury to determine. Is that still the law, or has the law changed?
Whether or not that's the law, off of the top of my head, I can't. I think case law also states that, I think that goes to whether, I believe if I believe you're asking what I think you're asking, I think that goes to also the summary judgment, and whether or not a motion for summary judgment, if that is a part of the motion for summary judgment, and whether that could be granted, whether the trier of fact would be able to reasonably come to a different conclusion. And at this point, I guess it goes to whether or not there's a genuine issue of material fact. And in this case, I don't believe that there is a genuine issue of material fact.
Well, what about the first part of the statement? Whether the plaintiff exercised reasonable care and diligence in discovering the injury. Is there any question here as to whether or not she exercised reasonable care and diligence in discovering the injury?
In this case, I don't think that there is a question that she exercised that, but I don't think that that is the standard for whether or not the discovery rule applies, or if the statute of limitations can be accrued to a later date. She may have exercised due diligence in going to the medical provider. However, on that date, on July 13th, she was still put on notice of an injury or the possibility of an injury. And I think that alone makes it so that the accrual date begins then and not at a later date.
Why would she
Because-
why would she want to go to a medical provider if she did not feel any pain, or there was no outward indication that she was actually physically injured?
Your Honor, I see that my time has expired. Are you okay with me answering, or?
Yes, go ahead.
Okay. I think because at the time of the incident, the plaintiff claims that she is paralyzed and she has these medical complications. At the time of the incident, in her complaint, she states that her wheelchair fell on her and that her leg was tangled. And I understand that she's paralyzed and she may not have that feeling. However, she was still put on enough notice of information, of facts, that would lead a reasonable person to believe that they may have been injured, that there was a cognizable damage done because of maybe a breach of duty, in which was alleged that our Ethra driver was negligent, and a damage that came from that.
Thank you.
Thank you, Your Honors.
Thank you. Hear from the appellant rebuttal.
Your Honors, I believe that opposing counsel said something there at the end that was very telling in this case. I believe
If you
her,
would, sorry, move back
Sorry.
from the microphone so we can hear. Thank you.
I think her words were, she may have been injured. And that's what we're arguing here. She may have, she may not have. But until Miss Jordan goes to a doctor who can tell her for sure or not if she has an injury, which she cannot feel, we don't know if that injury exists.
Counselor, is there any evidence in this case that there's some sort of visual indication of an injury, either to her face or her leg? And we've heard her leg got caught up. And is there anything, go through the record here, or you see, well, discoloration or something like that? Is there anything like that in the record?
There is nothing. I am in receipt of the Ethra report, and I am in receipt of the termination of the employee. But, the
There was
employee
nothing put before the
says,
trial court, though, in terms of facts that said actually her face was scratched up or her leg had some kind of discoloration that wasn't before the
No,
trial
Your
court
Honor.
in terms. Okay.
it was not. And the fact that the Ethra employee asked her if she was okay, she clearly couldn't tell if she was injured or not. She asked her if she was okay. And my client says on the video, which we can hear, says, I don't know, I'm paralyzed, I won't know until I go to the doctor. Which leads me back to the issue of the Ethra employee says in this report that my client told her she broke her legs. And we haven't discussed that with this employee. We haven't had a chance to depose her. That is just something that came out that we were unaware of. And
So here, opposing counsel says essentially she was at a sufficient basis to inquire. I mean, she fell, she knows her leg got caught up, she knows she hit her face. There's enough of a basis here to inquire. Your position, you're saying, well, she didn't really discover the injury, though, until she goes to see the doctor, and the doctor says, yes, in fact, this has happened, because she can't feel it, and we have no facts that show some sort of visual indication of it. Which of those two dates controls? And why does the latter date control over the former date? The discovery of the injury over the inquiry to look into it?
It's because of the discovery rule, Your Honor. Her injury was unknown at the time. We have that from Ms. Jordan telling the Ethra employee, I don't know, I'm paralyzed, I won't know until I go to the doctor. And it's unknowable to her. She doesn't have any pain, okay? Now, how did she get to the doctor? I think one of you guys asked that question. One of your honors asked that question. I apologize. You asked that question. It was an unrelated doctor's appointment. And that's important because Ms. Jordan is wheelchair bound. She can't just go to the doctor like we can. She has to use and reserve Ethra's services or someone else's time out of the goodness of their heart to transport her to the doctor. Now, when she gets to the doctor's appointment, she does tell them, hey, I fell, will you check me out? And I'm paraphrasing what she said. But she asked the doctors to do an exam. And that's where we find out that she actually has an injury. And at that point, Ms. Jordan has a legally cognizable injury. And therefore, the motion for summary judgment should not apply in this case. And that's why we're here today.
Would you agree that it's still an open question as to whether or not she exercised reasonable care and diligence in discovering the injury?
Are you asking me the same question you asked opposing counsel, if that's still the rule?
Pretty much.
I would agree with that, Your Honor. I have read this case and similar cases to it, and I didn't see that there's any change in that part of that opinion. And we would argue that 5 days to someone who is wheelchair bound and must use someone else's help and assistance to see the doctor to get this diagnosis, 5 days is reasonable in exercising her due diligence and finding out whether or not she actually has an injury. And one last thing, and I want to say that she was required to file it on the 13th. She did not know her injury. There's no way she could have known that. And I just don't see how that's possible. Thank you, Your Honor.
Thank you. Our thanks to counsel for both sides. We appreciate your arguments today and your briefs on this matter.